A letter before action sounds dramatic, doesn't it? Like someone in a wig is about to burst through a door shouting, "Release the paperwork!" In real life, it is usually less theatrical. No smoke machine, no courtroom thunder. Usually just a formal letter, a clear summary, and a polite but firm explanation that a court claim may follow if the dispute is not resolved. In small claims, a letter before action is often part of the pre-action stage. That stage generally exists so both sides can understand the dispute before court proceedings begin. It usually involves setting out the problem, the amount claimed, the basic evidence, and the outcome being sought. So where does a solicitor fit into all of this? A common question in small claims is whether a solicitor is used for the letter before action, or whether the letter is prepared without one. The answer in practice usually depends on the size of the dispute, the complexity of the facts, the confidence of the person preparing the letter, and the budget available. Small claims are designed to be more accessible than higher-value litigation. The process is generally used for lower-value civil disputes, often involving unpaid invoices, faulty work, damaged goods, deposits, or disagreements about services. Because of that, many people deal with the early paperwork themselves. That does not mean solicitors are absent from small claims. Solicitors are sometimes involved, especially where the facts are messy, the contract wording is awkward, or the dispute has become emotionally spicy. And by spicy, that usually means the email chain has gone from "kind regards" to "as previously stated" in bold. A solicitor's role at the letter before action stage is typically to present the claim clearly. That can include identifying the parties, summarizing the background, explaining the legal basis of the claim, setting out the amount claimed, referring to key documents, and stating a response deadline. One feature often associated with a solicitor's letter is structure. A well-drafted solicitor's letter can look formal, organized, and focused. Sometimes, the arrival of a solicitor's letter changes the tone of a dispute. Not magically, of course. It is not a legal wand. But it can signal that the matter is being treated seriously. There can also be a cost issue. Small claims usually have limited recovery of legal costs. That means solicitor fees for preparing a letter before action may not automatically come back from the other side, even where the claim later succeeds. In many small claims, solicitor costs are a practical spending decision rather than a guaranteed recoverable item. That point matters because the cost of legal help can sometimes become a large slice of a small dispute. A £500 unpaid invoice and a solicitor's bill doing star jumps in the background may not be a happy pairing. On the other hand, some situations are less straightforward. A dispute might involve several invoices, unclear contract terms, a denial of liability, allegations about poor workmanship, limitation issues, or a counterclaim. In those situations, legal input is sometimes used to help frame the dispute accurately. There is also a difference between full representation and limited help. Some people pay for a solicitor to review a draft letter. Some pay for the letter to be written. Some instruct a solicitor only after the response arrives. Others keep everything informal until court papers become more likely. So the solicitor question is not really a simple yes or no question. In practice, it is more like a weighing exercise. On one side, clarity, legal framing, formality, and reduced drafting stress. On the other side, cost, proportionality, and the small claims limit on legal cost recovery. A letter before action is generally expected to be clear rather than aggressive. It usually explains what happened, what is being claimed, how the amount has been calculated, what documents support the claim, and what response is expected. The tone is commonly firm, but not volcanic. The court may later look at whether the parties behaved sensibly during the pre-action stage, not whether a letter sounded like a pirate ransom note. For a quick example, imagine Adam, a sole trader electrician, and Bob, his client with the famous white mug. Adam says an invoice remains unpaid after work at Bob's shop. Bob says part of the work was not finished. A letter before action in that type of dispute would typically set out the job, the invoice, the amount claimed, the disagreement, and the documents being relied on. A solicitor might be used if the contract terms or evidence are unclear, or the letter might be prepared without one if the facts are simple and the amount is modest. That is the practical picture. A solicitor may add polish, structure, and legal framing. But in small claims, the cost of that help is often part of the wider calculation, because legal cost recovery is limited. The big takeaway is this: a letter before action is usually about clarity before court. Solicitors sometimes help create that clarity, but small claims are also built for ordinary people and small businesses to understand the process without needing a legal orchestra in the corner. And sadly, no wigs are included.